applied for the web page 6 months earlier, I wouldn't have had to use the D. When I was invited to give this talk, I thought a bit about what I wanted to talk about. And I considered very briefly giving a talk on the virtues of the free market. But I presume that pretty nearly everybody in the audience already believes in the virtues of the free market. And I long ago concluded that preaching to the converted was a waste of time for both speaker and audience. But then it occurred to me that the event is in honor of my father, and that my father's expressed opinion was that persuading people of the virtues of free markets was his hobby. His profession was scientific economics. And so I thought I would take the liberty of talking not about the virtues of free markets, but about some things I've studied in the last few years that I think are relevant to this conference and are also inherently interesting, which is the main reason I study stuff. I invented some time ago a new course, a law school course, which I called Legal Systems Very Different from Ours. And the basic idea was that all human societies face about the same problems. They solve them in an interesting variety of different ways. There is no good evidence that we are smarter than other people in other times and places, and it therefore makes sense to try to understand other legal systems, to treat them seriously as the work of adults, as maybe better solutions, maybe worse solutions, but at least solutions worth understanding. And I had a list of societies. I taught the seminar for a while. I got bored with some of them, so I went looking for some new ones. And one of the ones that occurred to me was Jewish law. And so I spent some time. I should say the danger of giving a talk on Jewish law here is that Israel is the one country in the world where there's a sizable chance that someone in the audience knows more about the subject than I do. But that's all right. If someone knows more than I do, I can get my errors corrected after the talk is over, and then I'll know a little bit more. Jewish law, I believe, is the best documented legal system in the history of the world. The only possible competitor I can think of is Chinese law, but I don't think we know nearly as much about it. Anglo-American common law is only about 1,000 years old, and we don't have very much information on it prior to the last few hundred years. In the case of Jewish law, not only is it well over 2,000 years old, but there is a thick, detailed treatise on the subject called the Mishnah that was written 2,000 years ago. So you can actually see the equivalent, as it were, of a law textbook from 2,000 years ago. Since then, there have been many other such books. My favorite is Maimonides' Mishnah Torah, because Maimonides, unlike everybody else in the field, to every question gives only one answer, which makes it much easier to understand him. My other source was a modern book by Menachem Ilan, a 4-volume book on Jewish law. And I think I learned some interesting things in the process. I should say, in addition to the treatises, there are literally hundreds of thousands of surviving cases. They are in the form of what are called responsa. You're a judge somewhere in the diaspora, you have a hard case, you write up the case, you send it to some legal authority you trust, and he eventually sends you an answer. And hundreds of thousands of those survive. So we really have an extraordinarily well-documented, as well as very sophisticated and interesting legal system. One of the interesting features of the legal system is that it survived the state that created it. All right? Any legal system faces the problem of judicial uniformity. How do we make sure that if you go to different courts, you get at least about the same verdict? And the solution that Jewish law originally came up with was majority vote of the legal scholars. The legal scholars were organized into the Sanhedrin, which was sort of the court system, and they chose to interpret a passage in Torah as implying that they got by majority vote to decide what the law is. I could give a different talk on the ways in which Jewish legal scholars over the years have done the same sorts of things that we accuse American Supreme Court justices of doing. Indeed, I've sometimes suggested that by the standards of the rabbis, every Supreme Court justice in history was a strict constructionist. But that would be for another talk. But in any case, the original system was basically majority vote of the Sanhedrin, but then the Romans wiped out the kingdom of Israel. And after a little while, the Sanhedrin faded out of existence. And yet, it continued to be the case for most of the next 2,000 years that most Jews were living under Jewish law. Because the Christian and Muslim rulers they were living under found that the easiest way of dealing with their Jewish subjects was to subcontract the job of ruling them to the Jewish communal authorities in exchange for taxes. And then the Jewish communal authorities had Jewish courts enforcing Jewish law. For about the first 700 or 800 years after the Sanhedrin went away, there was a sort of a de facto Supreme Court, because the Babylonian academies, the heads of the Babylonian academies were considered the greatest experts on the law, so more or less their rulings held. They eventually lost their authority. So for about the last 1,000 years, you had a functioning legal system with no formal way of settling disputes among the judges, and yet it worked. And it very largely worked through argument. It worked through people like Maimonides and various others writing persuasive and very learned treatises, and to varying degrees succeeding in persuading the judges in different parts of the diaspora of their views of the law. It wasn't a perfectly uniform system, neither is ours, but it nonetheless survived and functioned for nearly 1,000 years after its last central authority vanished. And that's pretty impressive, and I think is also interesting from the standpoint of this conference, because although it's not exactly a free market, it is sort of like a free market. One of the things that struck me looking at this was that Maimonides, or possibly the previous scholars who he was echoing, were pretty good economists. There's some very nice law and econ in the Mishnah Torah. And the particular bit that I like is the discussion of damages for tort injury. And the question is, you have negligently caused me to lose my hand. What do you owe me? And Maimonides has a list of 5 categories, of which I'll only mention 2 of them. And one of the categories is the fact that it is undesirable to be only one-handed. Now, how does an economist figure out how much undesirable? How much money does this correspond to? Well, the answer is clear. We need a market. Maimonides had a market. So Maimonides answers, you say, well, suppose you were being sold as a slave. Because there was slavery then. If you were sold as a slave, how much would you sell for whole? And how much would you sell for minus one hand? The difference is the tort damages for your permanent injury. Well, he says another category is pain and suffering. And how would he measure that? Well, he doesn't have a market, unfortunately, so he's got to make it a Gedanken experiment, a conceptual experiment. He says, you ask for the particular person who has suffered this injury, if the king condemned him to have his hand cut off, how much would he pay to have it done under drugs? Right? Their equivalent of anesthetic. That's the pain and suffering cost that he suffered. And being a good economist, he says, now of course this means that the damages for pain and suffering will on average be higher for richer people because they'd be willing to pay more. And they'll be higher for sensitive people than for very tough-minded, thick-skinned people. But that's all right. That's what the real damages are. So that struck me just as an interesting example of a thinker roughly 1,000 years ago, maybe earlier. Since I haven't read most people in between Mishnah and Maimonides, I don't really know which ideas are his. But I'll credit him with all of them. So that was rather neat. Another bit that struck me as interesting and is relevant to our subject in a backwards kind of way, because it's about religion supporting the market, not the market supporting religion. And that's an odd bit that you see in Jewish law, but also I've observed in a number of other law codes. And that's the role of oaths. So I believe you have stolen my cow, but I don't have much evidence for it. And I accuse you before the court. And the rule is that since I don't really have much evidence you've done it, you can swear and be quit. Which means if you were willing to swear the appropriate religious oath that you didn't do it, the case is over. All right? Your case is dismissed. Now we change the case, so now I have quite a lot of evidence. And now the burdens of swearing switches, and now I, the plaintiff, can swear and take. If I am willing to swear this oath, now I win my case. And there are various intermediate cases I'm not discussing. And the clear implication of that is that people were reluctant to swear falsely. And that therefore, the existence of this procedure, in effect, gave them a lie detector, not a perfect lie detector. Well, how do we know if people are reluctant to swear falsely? And part of the answer is that there are 2 different reasons why you might not be permitted to swear. First, if you have sworn in the past and it then turned out that what you swore to wasn't true, you aren't going to be able to swear again. Second, if from observing your behavior, it is clear that you are not somebody who follows the religious law, then they won't accept your oath. And not accepting your oath is a cost. It means in certain circumstances you can't swear and be free or swear and take. And it occurred to me that an odd way of looking at that is that one function of religious restrictions like the kosher laws is to make the lie detector work. Because after all, if I really believe in the religion, then of course I will keep kosher and do a lot more elaborate things that Maimonides spends the 10 volumes of this book that I haven't read explaining in great detail. And then I will also be afraid of divine vengeance, or at least I will want to do what God wills, and therefore won't swear falsely. Whereas if I'm an unbeliever who doesn't want to say I'm an unbeliever, I'll be careless about following the religious law. They will recognize that, and they will therefore know they can't trust my oaths. So it struck me as an interesting case in which religion was really feeding into the law. And I should say it's not the only one. I'm only talking about Jewish law, but of course I've been looking at a bunch of other systems. You observe versions of the swear and take pattern in Sharia. You observe a version of it in one of the Plains Indian legal systems, and undoubtedly in some others. Probably it's traditional Somali law, but I'd have to check that to make sure. But it's a very interesting way in which the systems go together. Let me now go on to a different topic. This is sort of a random selection of interesting bits and pieces that I've come across. It's not a coherent theory of anything. That will be for many years in the future. There are a couple of interesting features of Jewish law which I think I understand, and I think they're fossils. And one of them involves the following situation. We have a legal dispute, and the court is sure I owe you 50 zuz and thinks I might owe you 100 zuz. The money that Maimonides cites. So for example, you lent me some money, and we did a very sloppy job of the paperwork. And the result is that on one page it says 50 and on one page it says 100. And so the court is sure I owe you at least 50, but I might owe you 100. And what is the implication of that? The consequence is the court can make me give you 50, but they can't make me give you 100. Right? So far, perfectly straightforward. But, Maimonides adds, if you happen to have seized 100 zuz from me, the court can't make you give 50 back. All right? So if you have engaged in self-help and collected the damages yourself, they couldn't make me give you 100 because they're not sure that I owe you 100, but they can't make you give me back part of it because they're not sure I don't owe you 100. All right? So you let it stand as it was in that case. And second bit that related to the same thing, and that's the existence of the avenger of blood in murder cases. If you kill somebody, you are supposed to be tried by a court, and if the killing was deliberate and you did it yourself, it's a capital offense and you're executed. If not, you are sent into exile in one of the cities of refuge, and you remain there until the high priest dies. Right? All of that straightforward. However, if you were to be executed, you are supposed to be executed by the avenger of blood, who is the heir of the person you killed. And if you were not to be executed and the avenger of blood catches you outside of the city of refuge on your way there, he can kill you with no legal penalty. What is going on in both of these? What is going on in both of these are the fossilized remnants of the feud system. All right? One of the forms of law, one of the very interesting forms, which I think gets much too much of a bad press among moderns, is feud. And that the way a feud system works, it's a way of enforcing law, it's a way that's been used by many societies, some of them pretty successfully, is that if you wrong me, I use force or the threat of force to either get vengeance or make you pay me compensation. And in a well-functioning feud system, there are some mechanisms by which everybody else figures out whether I've really been wronged. And if I am a bully who's trying to make you pay money you don't owe me, everybody allies with you. And if I'm not, everybody allies with me. And the result is that you get de facto real law enforcement, even though it looks from a great distance like a might makes right kind of system. I've written about the Icelandic system, which lasted for a third of a millennium along those lines. Worked quite well. So I think it's pretty clear that what's going on here is that there was a feud system pre-existing Jewish law as we know it, that the avenger of blood was the person who was supposed to get vengeance for the killing, and now he's preserved in this. Now, I should say the Jewish law specifically forbids what the Icelandic law regarded as normal, namely a money payment to compensate for killing. Wergeld is the Icelandic term. And the Jewish law says you are not to accept money to compensate for killing. You've got to kill the person. But you wouldn't tell people not to do something unless they were doing it. So my interpretation, again, is that you are suppressing a previously existing pure feud system in favor of this later system of feud. And I should say, Sharia also contains fossilized evidence of the same thing. Now, unfortunately, I don't have enough time to do the last bit I was going to do, but I will tell you, I can tell it to people at some point afterwards, it is a Talmudic story, which I wanted especially for Randy Barnett, because it is an early argument against judging the law by what the people who wrote it intended. Because it is a debate between the halakhic scholars and God, and the halakhic scholars refuse to accept God's account of what the law is. This is the story of the furnace of Achnai, but I think I'm almost out of time, if I'm not mistaken, so I don't think I have time to tell it to you now. But it's a neat story. All right. Rabbi Eliezer was, as far as I can tell, one of the leading, perhaps the leading halakhic scholar at the time. And he was, I think, the leading member of the school of Shammai at a time when there were two schools of legal thought in Israel. This is about the 1st century AD, I think. The school of Shammai was the minority, the school of Hillel was the majority. And there was a debate between Eliezer and the sages, who I think are the scholars of Hillel, on a very unimportant technical point, which was you have a clay oven which has been polluted. It's touched a dead body. And you purify clay objects by breaking them up. So suppose you break the oven and you then reassemble it with sand between the pieces. Is it now pure or impure? And Eliezer said pure, and the sages said impure. And Eliezer offered every possible argument for his position, and the sages refused to be convinced. And finally Eliezer said, if I am right, let this carob tree testify I am right. And the carob tree uprooted itself and flung itself a long distance downwind. And Rabbi Joshua, who was one of the sages, said, a carob tree has nothing to contribute to the disputes of sages. So Eliezer went on and he gave more and more arguments. And finally, when he still couldn't persuade the sages, he said, if I am right, let this stream testify I am right. And the stream turned around and started flowing uphill. And Joshua said, a stream has nothing to contribute to the disputes of sages. Goes on again. And finally he said, if I am right, let this hall we are speaking in testify I am right. And the walls of the hall began to lean in. And Joshua looked up at them and he said, it is not for you to interfere in the disputes of sages. And out of respect to him, they stopped moving, and out of respect to Eliezer, they didn't go back up straight. Argument continues. He still can't persuade the sages. And finally he says, let heaven testify I am right. And out of heaven comes a voice, saying in all matters of the law, Eliezer is correct. And Joshua looks up and he says, it is not in heaven, which I interpret as, but out. All right? Now the theory of that is God gave man the job of interpreting the law. The majority of the sages, which is us, because Hillel's got the majority, get to interpret it, so God can interfere. And that, it seems a little illogical, because you might say, yes, but once God has told the sages what the law was, why don't they all change their votes? But I think the real point, as I interpret it, is that when you have a legal system based on divine revelation, you have the danger that a sufficiently convincing charismatic leader can claim he's got a pipeline to God and then rewrite the law. And that's not a satisfactory situation. So the point of the story as I read it, and I'm not sure I'm right, is even with overwhelming evidence, even when it's clear that in fact he does have a pipeline to God, you still aren't willing to accept it. Now I should say the story gets darker further on, which is part of the reason I'm not sure I understand it. Because when they vanish, they excommunicate Eliezer, because presumably he's telling his people to continue judging by his opinion rather than the majority opinion. And when they do that, according to one account, a third of the olives and a third of the wheat and a third of the barley of the world were destroyed. And eventually, Eliezer's wife is the sister of the head of the Sanhedrin. And his wife has instructed him not to fall on his face in petitionary prayer. And at one point when she is distracted, he does. and from her brother's house comes the sound of the shofar announcing his death. So it looks as though when Eleazar finally gets around to complaining to God about how he's been treated, God promptly strikes dead the leader of the other side. So it's not clear that I fully understand the story, which is part of what makes it interesting, but nonetheless it is a story about rejecting the opinion of the author of the law when the author is around to give it, which is part of what makes it interesting. Thank you.
Thank you.